remember the Christmas novel Scrooge? And what I remember of it and what's fitting for estate planning was to try to get the point across here is you had the present ghost, you had the past ghost, and you had the future ghost. And so when he was visited by the past ghost, he was, he looked, they were just taking him through his past, kind of how he evolved with this Scroogey-like attitude. And then, of course, his present situation, present ghost was visited by, and then, of course, the future. And the future was where he was alarmed. In other words, he wanted to make changes, as we know in the movie. Well, I look at that scenario as far as the present and the future ghost is very similar when it comes to estate planning. Why is that? Because you got your present situation, you got all these assets that you've accumulated, IRAs, 401ks, homes, second homes, rental properties, whatever they may be. Those are everything that you've accumulated over a lot of years. And then when you step into retirement, now you're going to distribute income to you for those assets in hopes to preserve, and then you're going to ultimately give those assets to your children. So the goal is, just like Scrooge seen in the future ghost, is to be able to, in a perfect way, for you to design your perfect estate plan. That's the whole point of it. But you got to understand what causes, what things could actually be problems into the future if you don't know what they are ahead of time. Because it kind of reminds me, because when it comes to estate plan, we think of wills and trust and, power of attorneys and so forth. And those are great to know and understand, and they're all excellent tools. But, you don't know exactly how you're going to pass, other than we know we're going to pass away, but we don't know to what kind of cost it's going to cost us when we pass and so forth. So, some people, all they really need is just a will, and at least if you had a will, that'd be great. But in most cases, most people want to go above and beyond that. And there's a lot of reasons why. Because estate planning is not just for the wealthy anymore. If you have IRAs and 401ks and you have more than one child, I did say more than one child, it's a little easier if you only have one child. But if you have more than one, then you have every reason to have some kind of estate plan. Whatever you do, at a minimum, do a will. Because if you die intestate, and intestate means you forgot to do a will, then you don't have to worry. There is still an estate plan that's already provided for you. It's called the state retirement plan. So the state of Kentucky, if you live in the state of Kentucky, if you live in Florida, wherever, they are going to have an estate plan already provided for you. And it's going to be the way they distribute the assets, no longer the way you distribute assets. So most people, in most cases, want to leave at least a will behind. But let's go a little step further. I'm going to give you a scenario of a particular client that I met with in 2016. I'm trying to go off memory here. And when I met with her, she had lost her husband like 2 to 3 years prior. And she came in as a referral from a friend of her sister, who was actually a client of ours. And she had this lump sum amount of money. I could tell she was very conservative. She didn't want to take a lot of risk. And so she had about $500,000. And she says, listen, all I care about is living off the income from this right here. Per the trust, I'm allowed to do that. And also that $500,000 has to be passed to my deceased husband's 5 children, unless I need future medical care with these resources. She went on to say that she sold the mini farm that he and her lived in. It was ultimately his property. Keep in mind, these people had 2 marriages, so he had his kids and she had hers. Good news is she only had 1 child, didn't have 2 or 3, so she only had 1 son to deal with. The good news is she had a rental property, which before they got married was her own house. So she wound up renting it out and collecting some income. Also, the ex-deceased, or not the ex-husband, but the deceased husband, put together a trust. And in that trust, he made her the trustee. So she was in charge of not just the $500,000 I'm talking about, but also 5 rental properties that he had, because he had 5 children. Now follow me here for a moment. The goal for him was ultimately to take care of his wife, since he predeceased her. And she hadn't really done an estate plan for herself yet, but she, as a trustee, wanted to make sure that she did exactly what the trust document says, and that was to distribute the assets the way it was supposed to be done upon her death. Well, he wanted each one of the children each to get 1 rental property apiece. And 2 of the 5 children was not even aware of the trust. Immediately after, somewhere a few months after the passing, and decided to start harassing her about getting their inheritance. Well, the point of the 5 rental properties was to provide her income while she was still in retirement. Well, they kept harassing her to the point, now 2 of the 5 children, the other 3 children were pretty amicable, so they were okay with the way way everything was going to be divvied out upon her death, but 2 did not. Matter of fact, it was really stressing her out because she was in her low 80s when I met with her during this time. Matter of fact, when I meet with her now, she's still talking about it because they're still harassing her, to the point where she actually started negotiating. She just wanted them off her back. But she didn't have to, because, see, her deceased husband, who was the father of these children, probably knew these children. And as you know and I know, children don't always agree on everything perfectly, right? So there's a good reason to do an estate plan. In this case, they didn't agree. And not only that, they just assumed probably that the estate, after Dad passed, that they were going to get their assets, not realizing he had already put it in the trust. He did that to save them from themselves. So whenever she finally decided, after they decided not to negotiate with her, she was the trustee of the trust. She didn't have to do anything because the trust protected her from dealing with them. So many people would say, well, what if that would have been a will instead of the trust? Keep in mind, a trust means you cannot hardly contest a trust, because the trust is the dying wishes, in this case, of the father of these five children, and they're going to have to follow the commands of the trust, the written language of the trust, and the trustee's the one that makes the decisions. Because the trust now owns those 5 rental properties. So if they had had a will, then the will would have been contested, and who knows, they may have actually won. Because see, whenever you have a will, and you're, especially when you're involved in children, they can contest it. If you disinherit children, they can also contest it, because it's going to go through probate, which is an extra cost. Also, you may have to have attorney representation, which is extra cost, all because of you have a will. There's nothing wrong with a will, but the reason I described this scenario, the trust made more sense than the will. That's my whole point. So you see, nobody really knows the difference between they know the difference between a will and trust, but they don't know which one makes the most sense for them. Only you know. But you want to be able to know the inside out, the outcome of a will and the outcome of a trust. What's it going to look like? Just like the future ghost presented the problem with Scrooge. So with that being said, there is 3 phases to estate planning. Okay, not one, this distribution of the assets, but there's 3 phases. The phase that most of you are aware of is if you're more likely in retirement, this is behind you now. This is the past. Okay? This is where you accumulated assets for the purpose of retiring, right? And then when you stepped in retirement, the goal is to preserve your assets while you're alive. Okay? And then ultimately the distribution of your assets when you pass. Well, we call this estate leakage while you're alive and estate leakage when you pass. So you prepare a plan so that way you can avoid you're going to pay an attorney to put together a plan, but you don't want to have unnecessary additional fees because you didn't do the right plan, and there's where you can have attorney fees, unnecessary attorney fees. You can have unnecessary probate fees. Probate fees are determined it's a court system that determines whether the will is correct and valid and so forth. But the thing is, though, anytime you interrupt anybody in the government, you're going to have to pay them of whatever the fees are going to be. And by the way, if you're 60, 65 years old or even 70, this is going to be probably 15 or 20 years down the road. So you can imagine the cost today, add inflation to it in the future. That's what the costs are going to be. You got estate tax. That's only if your estate is in excess of whatever the exemption is today, 2024. It's the estate tax is $13.6 million and some change, and under you don't have to pay any estate taxes. But if it's over $13.6 million, you're single, you are going to pay up to 40% estate taxes any dollar over. That's what they call it, the threshold. The same way if you're married, then it's double that, $27.2 million. So estate tax only depends on how much your total estate is worth. Anything in excess of that, you're going to have to pay tax. And then lastly, income tax. Income tax, what assets can you pass that are going to be income taxable? IRAs and 401ks. So do you want to pass an IRA? You got to understand there's going to be taxes at your death that your heirs are going to have to be responsible for. That's at your death. This is the unnecessary leakage that sometimes people are planning now ahead of time to try to avoid. Now, this is why you're alive, while you're living leakage. You got income taxes. Again, this is IRAs and 401ks and also brokerage accounts, anything that's that you pay taxes on. You get 1099s and capital gains and so forth. You got investment fees. Investment fees are fees like you have mutual funds, or if you have exchange traded funds, then you're paying one set of fees that are called expense fees because there's a management team that's actually managing those assets. The reason I bring that up because most people that are probably watching this are probably in two of those instruments. And so sometimes we find that people pay unnecessary investment fees. So you want to know, are the fees worth it? Because that can be leakage, and you can avoid that if you knew how to minimize that. And lawsuits, how can you do to protect your assets now going forward? So in the right trust will be able to determine that. Catastrophic medical care, what can you do to protect maybe your home? And or get long-term care insurance. These are, the last 5-yard line of life, so to speak. This is when people run into the highest cost of medical care. And the last one, which most people don't think about, is you're using your assets for the purpose of income. The question is, are you spending your assets or are you just living on the income that your assets provide? If you're living on the income that your assets provide, which our clients do, ultimately you can preserve your assets and have ideally the retirement plan you want. That way you can leave as much of a legacy as possible. You can have your cake and eat it too if you preserve correctly. But the word preservation today is really used flippantly in a lot of ways. Just because I tell you I'm preserving doesn't mean I'm truly preserving, because that's going to depend on market cooperation, especially the way retirement plans are designed today. So I'm going to call this part 1 of Estate Plan 101, and then I'm going to have part 2 where I'm going to go a little bit more in depth on accidental asset spin down, how that works, and then also what you can do to be able to minimize these over here by using trust versus just nothing but a will. What's probatable, what's not. What also how you can designate beneficiaries correctly, so that way you can also bypass probate with some of your assets. Stay tuned. We're going to actually talk about that next. As you're watching both Part 1 and Part 2 of Estate Planning 101, for the sake, and I'm going to make a disclaimer here. I am not an attorney, and I'm not making any kind of legal determinations when it comes to your final estate plan. I'm involved with estate planning due to the fact is every client that becomes a client of ours, we always want to make sure that they got their ducks in a row for preventive measures in the future. So I'm involved when it comes to estate plan, especially when it comes to our clients, because we always ask them, do you have a will or do you have a trust? If not, and then we will actually make sure that they take care of those issues, because I think they're extremely important. And estate planning to me is extremely important because my dad's been telling me ever since I was probably in my 30s. He had different trusts set up for different functions whenever he was in his mid 40s, and so estate planning was something that I've always thought was extremely important, and because I had a very good mentor. And so, with that being said, I am not an attorney. Also, when it comes to taxes, if you have a tax advisor, then sometimes taxes you need to involve your accountant or your CPA. So just for the sake of disclosure, I just want you to know that I'm not neither. I'm involved with this. And a lot of times what we find is with my experience with people coming in and meeting with us that already had estate plans put in place, they used a estate planning firm or somebody that did it as a side gig. In other words, that wasn't what they specialize in. And so they wind up having a plan that they know that needs to change, and actually they need to upgrade it to some extent. And so, again, you want them to make sure you do those updates, because wheels get rusty, right? Things change. I mean, maybe there's some people that's passed away or whatever it may be. You want to make sure that you're constantly updating. A good estate planning firm is actually going to keep you on top of that. But what I have found is sometimes when somebody passes, nobody really communicates that clearly to estate planning attorneys, or been in my experience, a lot of times they give us a call on the financial planning side, and then that's whenever we get involved and get them involved in that process. Because again, think about it for a moment. None of us want to make financial decisions immediately, right? We want to, especially when we lose a spouse, we've been told you shouldn't make any financial decisions for 1 to 2 years. Well, if that's the case, then you want to make sure that your estate plan is in order ahead of time, so that way both spouses know that upon if one pass or the other pass, they know exactly what to do. But where we're involved is you can't wait 1 or 2 years, right? I mean, you may have required minimum distributions you may have to take from your IRAs, and the one passed away. If you don't have ownership of that IRA, then you're going to have to make some decisions to make those changes. That's where we're involved. And there's many other instances I can give you. So with that being said, I hope you enjoy Part 1 and Part 2.